Hi everyone, thank you for joining us. It seems like we've got most of the attendees online, so we'll get started. By way of quick introduction, my name is Haroon Khwaja. I'm a senior associate in the technology, media and telecommunications practice of Tamimi, and I'm based out of the Dubai office. I mainly work on technology contracts and regulatory affairs concerning things like data protection, e-commerce, cybersecurity, and a host range of other things. Just before I introduce you to our speakers, panelists, I'll just go through some quick housekeeping items. So firstly, if you'd like to ask any questions, you'll see on your dashboard there's a space where you can click on and type in your questions, and we'll receive that, but we'll endeavour to answer those towards the end of the session. We've also got no slides, so you'll be delighted to hear that. You won't have to try to listen into the conversation and madly, read notes and put stuff down. And I'm sure you've got a bit of webinar fatigue, so we're trying to make this as interesting and interactive as possible. Finally, we're going to be circulating the recording, further information and contact details by way of email in a day or so. So please stay tuned in for that. There'll be also a lot of further detail in terms of how the various Escrow options work. So and additionally, if there isn't anything that comes to you at a later point, please do email us and we'll get back to you on those points. So we're hoping to cover a number of things today. Just briefly, we're hoping to cover the traditional software Escrow, the new Escrow as a service model, how they all work from a mechanics perspective, and also in terms of key legal provisions and things that you need to be mindful of. And we'll look at a quick case study around small vendors and fintech firms and what they're doing to help their customers. Without further ado, I'll pass on to Jamie so he can give us a quick intro on NCC Group, what they do, and what Jamie and Nicola do in their roles.
Great, thanks Haroon, and good morning everybody from Manchester in the UK. I hope you're all doing well. So before I introduce myself, I just wanted to give those listeners who are unfamiliar with NCC Group a bit of a background as to who we are. So NCC Group is a global organisation comprising of two key divisions. Firstly, our assurance division, which covers a whole breadth of cybersecurity and risk management practices, in addition to our Escrow and software resilience division, which is where both Nicola and I focus and sit within the organisation, with the primary focus of that particular division on software resilience, both on-premise and more recently cloud applications and technologies. A few, I suppose, additional statistics to give an indication as to the size of NCC Group. We've got roughly 1,800 employees globally that service north of 10,000 global customers, in addition to several thousand technology partners who both support and advocate our service offerings. Our customer base spans across organisations of all sizes, industries, as you can see. Unfortunately, from the slide that I haven't been able to show you, ultimately that gives you hopefully an indication of NCC Group as an organisation. In relation to myself, my name is Jamie Mackay. I'm the Head of Product and Solution Architecture at NCC Group. My main focus is to, I suppose, have technical and commercial ownership of our product roadmap, make sure that the products and services that we're offering to our customers are still fit for purpose, in addition to working very closely and then having overall responsibility of our solution architect team. The solution architect team ultimately work in a pre-sales capacity, working with our customers to make sure that they have the right Escrow solutions in place for the various business drivers that sit behind that. I'll pass now over to Nicola.
Hi, I'm Nicola, so I've been with NCC Group for 10 years. I'm a solicitor, so I started off in the main core legal department, and now I manage the legal operations for Escrow. So I basically focus on the contracts, really in-depth knowledge of negotiating them for the last 5 years, and I've been qualified for over 13 years. So that's me.
I should introduce myself as well. So I work with Haroon at Tamimi and Company. My name's Nick O'Connell. I am, at the best of times, based in Riyadh in Saudi Arabia, although I'm stranded in Dubai at the moment due to the pandemic. I do very similar work to Haroon, so I do a lot of technology contracting, but a lot of advisory work in the broader technology, media, telecommunications space, so data-related advisory and all sorts of things. In terms of Tamimi, I think because we do have a variety of attendees today, some of whom know us well and some of whom don't. Basically, Tamimi is the largest law firm in the Middle East. We have about 400 lawyers across 9 jurisdictions. So we're currently in all of the Gulf Arab states, as well as in Egypt, Jordan, and Iraq. And we're a full service firm, although we do have a very big technology, media and telecommunications practice. So we do a lot of work in this space. And so it's good to be able to talk to the team from NCC today in order to get a bit of insight into what they do, what they offer, and the escrow service provider's perspective on things.
Okay, great. Jeremy, do you want to kick off? Just let us know, from starting point, what is software escrow, and what is it good for? When would clients need to look into putting that sort of arrangements in place?
Yeah, absolutely. Thanks, Haroon. So from a software escrow perspective, ultimately what underpins software escrow arrangements is the legal contract. So for the past 20, 25 years that we've worked and been leaders within the software escrow market, primarily software escrow contracts have been based between 3 parties, so a beneficiary and usually an author or creator of software. And ultimately, the 3 parties, including NCC Group, will need to enter in that contract for primarily business continuity or supply chain disruption purposes. So ultimately, if you have a software vendor, if you're an organization that you engage or outsource to a software vendor to utilize a piece of software, more often than not, in terms of ways in which you can mitigate a risk if that software supplier is unable to provide that service to you anymore through things like insolvency or contractual breaches to the SLAs, for example, lots of organizations will utilize software escrow contract to mitigate that risk. And the contract itself, as I say, is between 3 parties, and the primary function of that escrow contract is to store, historically, source code. So source code for the application is something that the beneficiary or licensee wouldn't have access to, which has value and will enable business continuity after a point of failure. As time has evolved, so has software escrow. As obviously technology starts to evolve, customers now outsourcing to cloud arrangements, for example, new technologies emerging within the marketplace. Software escrow contracts have evolved as well to make sure that we're not only holding source code for our customers or on behalf of our customers and the software authors and vendors that we work with, but ultimately we're holding as much material as possible to enable that restoration of service after a point of failure as reliable and as quick as possible ultimately. So from I suppose to summarize it in terms of what is software escrow from a contract point of view, it is a risk mitigation strategy and service against supply chain disruption, and if there is an issue with your supplier, that means they're unable to provide that service to you any longer.
Yeah, and NCC's role in all that is really, it's almost kind of an independent agent that is really bound by the terms of the escrow agreement. So it's only when certain release events occur that NCC Group is then in a position to release that software escrow material to the customers. Nicola, could you expand on that? What are some of the typical release events that you see in a software escrow agreement?
Yeah, so in our agreements, we have 7 standard escrow release events, which are the ones that we recommend as almost the basic what every escrow agreement should include. So that includes insolvency, if a company is dissolved, bankrupt, an administrator is appointed. So all of those events that basically will mean the company's coming to an end and can no longer provide the solution, the services that you are requiring. sorry, they also may cease to just carry on their business in relation to your software. So if they just stopped providing that, or they might assign the IPR to another part of the business. So then you need to make sure that you continue to get your service, or fail to maintain the service. So if you've got a maintenance contract with them and they're not maintaining it, there's a material breach, then that would be a standard release clause as well. But we also do tailor to any release events that the parties may have agreed between them in their license agreement. So they might have agreed that a breach of a certain clause, or a payment of a certain amount of money, or a certain date is a trigger for the release of the source code, and we will accommodate whatever the parties' wishes are in that instance.
Yeah, and just focusing on the verification aspect, because I think a lot of clients think, well, here's a software source code that I have, I'll put it on a USB and give it to NCC, and sometimes they think they can give it to their lawyers to hold on Escrow, which we don't. And we've got some funny stories around that. But essentially, there's more than just source code that that clients need to be able to continue their services in the event that a release event is triggered. There's things like instructions and documentation. Jamie, can you expand on that a bit for us?
Yeah, absolutely. So from a verification point of view, that's really where I suppose the consultancy and sort of the business continuity documentation and value comes into our services. Naturally, from a contract perspective, we can have that contract between the three parties, we can store that material, and that gives a layer of protection to make sure that that intellectual property and that deposited material is safe and secure with NCC. But ultimately, you're absolutely right, Haroon, in terms of from a verification point of view, the ultimate question is, what is a customer going to do with this material? If doomsday does arrive and they need to utilize that material for their business continuity, what does that event look like? How long will it take? How much does it cost? What skill set and expertise do we need in order to actually stand up those applications? So from a verification point of view, we have different tiers of service that we offer, and that's generally sort of correlated and lined up towards the criticality of the application. So ultimately, from an entry-level perspective, in terms of verification that we offer, we sit down, our consultant will sit down and work with the vendor either virtually, as is probably common practice you'll appreciate at the moment, or in some cases we do go on site and work with them quite, I suppose, in an in-depth nature to actually understand their processes and how they work as a team and as I suppose, a development business. And ultimately, what we will do and what we will try to extract as part of that verification and that engagement is as much technical knowledge as possible. How does the application work? How is the source code built? How is it deployed? Are there any third-party tools that are being used? What language is the source code written in? All these types of information that you would never really generally know as part of an outsourcing arrangement. It isn't generally questions, from our experience, that you would ask an outsourced provider. How many are in your development team? What source code language is it written in? And ultimately, what we look to achieve and the objective of these verification exercises is to get a detailed and documented by NCC Group understanding of exactly how that application can be built and deployed independently of the software vendor, to make sure that all of that knowledge has been transferred into a document that has been created specifically for the purpose of Escrow. So once you get that release, once you get that CD, or once you get that virtual hard drive, for example, of material, you understand exactly how to use it, what's on there, how to use it, how long it takes. If you need to procure an Oracle license, for example, understanding what license you need to get and all those kinds of things. So ultimately, that's really where I suppose hopefully I've illustrated clearly the value in I suppose Escrow comes in that consultancy piece of work to make sure that customers are protected and they have the knowledge that they need to continue to run the application and service pre I suppose release event.
Yeah.
Sometimes we hear about instances where clients, instead of engaging with a specialist escrow service provider such as yourselves, they try to use sort of shortcuts or what they might perceive as simple options or cheaper options, etc. And Haroon alluded to this idea of someone handing their lawyers a USB drive saying, can you keep this for us? Can you talk a little bit about some of the sort of shortcuts that you guys may have encountered where people have unsuccessfully tried to not take the proper approach, use these sorts of shortcuts, and that it has ended in tears? Do you have any examples of of situations that people might try unsuccessfully?
Yeah, so I think I'll probably pick up from a technical point of view. I certainly am aware of various shortcuts people try to take in terms of doing technical consultancy engagements. But before I do that, I'm conscious, unfortunately, there seems to be a bit of background noise in there where I am. So Nicola, if you could cover it from a legal perspective, I'll certainly try and come back in somewhere slightly quieter and cover it from a technical consultancy point of view.
Yeah, I mean, obviously the clients we're engaging with have come to us, so we then know about the stories that come to us. We often see escrow agreements that have been negotiated between parties and aren't fit for purpose, so don't have full details about exactly what's being deposited, when it's being deposited, how the release will work, what happens if there's a dispute. So I think because we've worked throughout the kind of the life cycle of escrow, we can look at it and understand all of the elements. So a party will often say, we want our release to look like this, and then obviously we'll be reviewing it to make sure that actually practically it will go through and those deposits will be made. So kind of we're then backing onto that. We do have a lot of examples where people will come to us in a release situation, or they've got a dispute with the vendor, and we'll say, well, obviously you have to look at the escrow agreement. Did the escrow agreement cover that? And that release event may have been taken out by the owner and the licensee didn't dispute it. So when we're negotiating the agreement, we really do work with all of the parties to make sure that it's fair and that everybody's aware of the consequences of the changes that they're making if they're making it bespoke.
Yeah, well, that's a great point. I mean, verification can't be underestimated. I mean, we've seen scenarios where, you know, you can be given a source code, but to a layperson, that source code could be for anything. It reminds me of the story of I have a friend of mine who used to, who figured after a while that his manager wasn't reading his sales report in a tobacco company, started putting in the ingredients for a chocolate chip cookie in his reports, and lo and behold, you know, his manager clearly wasn't reading it and wasn't picking it up. And you can have similar scenarios in software escrow where the customer gets you know, a USB or whatever in what he thinks is the source code, and yet it could be either the source code for something else, or it could not even be source code and be completely useless to them. So I think that's where NCC group and escrow agents add real value to clients, in that because they've got the experience, they've been through the process so many times. In addition to advising on best practice, appropriate release events, they can also go through the actual process of verifying that the customer has in their hands what they, you know, believe they've got and not something else.
Yeah, there's a famous story that we did once get a Kylie Minogue CD. So that's going back a bit in time. You can see how long that story's been around for, but
It'd be worth its weight in gold now, I'm sure.
Yeah. So every time we get a deposit in, we even if you don't go through verification, we do a deposit check, and we'll make sure that there's source code on there, that the deposit can be accessed and that it's readable. You know, that there's no obvious glitches in it. So that's where the Kylie Minogue CD got sent back.
Now,
I think as well, just to add,
in terms of the contractual side of things, Nicola, you know, the way that I sort of view it is that the escrow service provider, you know, you're an independent third party basically, but of course you're having this three-way agreement with both the licensor and the licensee. You know, you're experts in what you do. You have your standard form agreements that, you know, are tried and trusted and so on. Do you ever find that you have licensees or possibly licensors essentially trying to negotiate the terms of your standard agreements on points that don't really need to be or shouldn't really be negotiated? Like, do they take a bit of an adversarial view against you as if you were the licensor?
Yeah, I mean, obviously, because we are that independent party, it's a balancing act all of the time, and we just need to make sure that the parties are giving us clear instructions and that they're both in agreement. Sometimes if we're explaining a point, then it's seen that we're the enemy, even though we're actually trying to be neutral. If obviously sometimes the software owner's arguing one point and we might agree with that. you know, it's interesting because we did do a review of what clauses are changed in our agreement, and all of the lawyers on the call at the moment will appreciate if you get an agreement in front of you and you can mark it up, sometimes you'll just change a sentence because you don't quite like the way it looks. You know, so we do sometimes find that really odd clauses are changed that we don't see the need, or say, for example, the first deposit, people will often say, I want the first deposit after this event has happened that we don't know about. So we need to make sure that that's clear, and that actually the deposit should be made within so many days of the escrow agreement. So so it is really key for us to make sure that we're looking at the language and the discussions that we're having and making sure that everything's clear, everybody knows exactly where they stand. And we will always try and be independent and not get drawn into arguments that obviously it isn't our place to get involved in.
Yeah, that's really for us, because unlike NCC, who's independent, we're not impartial at all, and so we're always when we're marking up these documents, you know, trying to expand the release events to make sure that there's more opportunities for our customers to get their hands on the material that they need to ensure continuity of access, and also increasing the scope and duration for which you know, to making sure that they can get the rights that they have obtained under the underlying license agreement. I think one point we've seen quite frequently is that clients are wanting to put escrow agreements into place well after they've negotiated the underlying license agreement. So there's a couple of issues. Firstly, they think they can get ownership of the source code, which you can't. And I think one of the purpose of the escrow agreement is to give you to give effect to what rights you had under the initial agreement, and no more than that. And because they're doing the negotiations or seeking to get the escrow arrangement into place well after they've negotiated the software license agreement, they find themselves in a position where the vendor's not really that keen on entertaining the escrow discussion. So what we recommend normally is make sure that you're negotiating your escrow agreement at the same time as your license agreement, or whether it be a software development agreement or managed services agreement, whatever it is. These two documents need to be negotiated simultaneously, and they also need to be, you know, speaking to one another.
That's definitely true. Exactly right. Like in the release events, we're always going to be backing up the license agreement. We're always going to be supporting whenever the deposits are meant to be made, what the deposits are meant to include, and the usage when we refer to release purposes, which is the purposes you can use the material for. We refer back to the license agreement and say you have whatever rights were granted to you in that license agreement. So if your right to use the material will end at the date that your license agreement is terminated and won't continue, then you won't be able to use that material that we released to you for very long. Yeah,
I think it's just important to really kind of highlight, you know, the limitations of an escrow agreement. It's not the be all and end all. It's probably a poor analogy, but I would compare it to like a spare tire. You know, if you've got an issue, you've got a backup, but it doesn't mean that you then go on to own the software or anything more than what you've got in terms of rights under the underlying agreement.
Yeah, that's right, and that's why we do refer back to that license agreement a lot. It's also why it's important for the parties to make sure they've reviewed the escrow agreement and it's completely fit for purpose, and that it really does say exactly what they want in the license agreement and the escrow agreement.
In terms of the events giving rise to release, the release events or the triggers, I understand that your template, you mentioned that you've got sort of 7 sort of standard release events that you include. Is it typical for, you know, when these agreements are used, is it typical for those 7 events to be used as is, or do people typically expect to have additional release events for their own circumstances, or is that uncommon?
Well, 70% of our escrow agreements are bespoke, which means they've been amended. And the clause that's most often amended, and the one we expect to be amended, is release events, because we understand that it really needs to reflect the commercial relationship between the parties. So, for example, we say that a material breach of the license agreement, failure to maintain, should be a release event. But the parties may have opinions on what material breach means, or there may be specific clauses that relate to that breach in in the license agreement. So it really does then need to be tailored down. So if you've invested a lot of money in your license agreement to make sure it's fit for purpose, then you also need to make sure you're investing that time in the escrow agreement so that they really do intertwine. So yeah, release events is definitely, I mean, that's the main thing we recommend to be altered, because it really is the key pivot that the agreement is based on.
And Jamie, so in terms of you know, a client saying, well, we've got hundreds of software in our business, you know, where do they start in terms of deciding which software products require an escrow? Or is it a case of saying, well, how critical is it to your business versus the cost? And do you assist clients with that analysis, or is that something that clients are to undertake on their own?
We contribute towards that analysis, and it tends to take place really when you do, I suppose, your supplier risk assessment. So if you're assessing an outsourcer dependent on organization size, how many customers that they have, their last year's revenue, etc., depending how you want to assess an organization that you want to outsource to and you want to trust with utilizing for a business function. Ultimately, what we recommend and the way that we work with all the businesses is understanding exactly how that categorization takes place. So just for argument's sake, if the very top level is a critical application and the bottom level is a low criticality application, ultimately, to ensure consistency across an organization, because that, I suppose, not wanting to divert too much, that is a problem that we tend to find with organizations, because there are lots of different individual stakeholders who have, I suppose, a vested interest in escrow. There is inconsistency in terms of the level of escrow that's applied to a number of different applications. So you might have some critical applications with just an escrow contract and some sort of medium to low criticality applications with our sort of top level of verification, and it's quite inconsistent across an organization. So what we generally recommend is to sit down with us, understand exactly how your categorization and criticality rating works at the moment, and then put together, or we can help you put together, an operating model or a risk matrix almost, to say, if it's this type of application, then this level of escrow should be applied. This is the contract that sits underneath it, and this is the verification with our favourable terms, etc., and how we want it to run that sits underneath that as well. Because going back to your point around sort of pre-procurement, if you can incorporate the standard escrow terms into your license contract that reflect the type of agreement and the type of service that you want, it's much easier to get that implemented pre sort of signature of that licensing agreement. And ultimately, you can then, from a reporting perspective, for whether it's for a regulator or internal compliance, say, okay, well, 50% of our critical applications are under this level of escrow, so the consistency is there, the protection is the same, and under a release event, what you would do with that material, again, the practice and policy would be the same as well. So it's quite important to almost benchmark what you want out of your escrow arrangement, rather than what we tend to find individual application owners come to us and say, we need escrow of some sort. We're not quite sure what that means at the moment. And obviously we try and sit down with them, benchmarking against what else has been done in an organisation. But it is worth spending that additional upfront effort to understand what you want out of escrow and how you want that to be applied across your business, because that will then streamline the process of implementing escrow upon procurement.
Okay.
That reminds me of, like, in some instances, organizations might have, like, they might be subject to, say, government procurement rules, or, some sort of, maybe a corporate policy or something that says, you must ensure that when you're obtaining software, that you also, have an escrow arrangement in place in respect of that software. But, basically what I understand from what you've said is that that won't necessarily make sense in every instance. So, if it's a high level of criticality, then for sure. But if it's, an off-the-shelf, if you're buying Windows or whatever, the idea that you would arrange an escrow sort of arrangement for that doesn't really make sense. Is that correct?
That's absolutely correct. Yeah, it depends how you want to, categorize the organizations that you work with. Is Microsoft or is Amazon or Oracle, etc. Would organizations deem them as high risk sort of vendors? Probably not, or certainly not from my experience. Doesn't mean some sort of protection shouldn't be in place. So we tend to work with the technology giants, for want of a better phrase, in terms of making sure that any additional configuration or any additional, I suppose, technology or software development that's been put on top of those platforms is taken into consideration. Because organizations generally, if it's a Microsoft product, for example, that perhaps either some internal or external developers have created an add-on for the organization, that from a line item point of view will still be categorized as one application. Whereas I suppose that the consideration has been taken into account that the add-on is actually part of that overall service, and that should potentially be placed in Escrow rather than obviously all the source code for Microsoft Word, which I have to say we've never had in an Escrow agreement. But ultimately, it's about just understanding, and that's really where I suppose getting technical stakeholders involved in the conversation, whereby you want to benchmark what your Escrow looks like. It is really where I suppose doing that sooner rather than later is certainly something we recommend, albeit that's easier said than done in some cases.
Okay, that's very helpful. And in terms of software as a service Escrow model, Jeremy, what would be the key differences, both in terms of the mechanics, the depositing of the material and the release events? And Nicola, if you could just follow that up with the key legal provisions that you're seeing that differ or additional compared to a traditional Escrow, that'd be helpful.
Yeah, absolutely. So I think from where people tend to sort of misunderstand, I suppose, the comparison between on-premise and cloud Escrow is that I suppose the underlying driver or business driver more often than not is the same. You're looking to protect against supply chain disruption. If your vendor isn't able to provide that service, regardless of whether it's on-premise or whether it's cloud, ultimately, you're protecting against that particular scenario. The difference that we tend to find with cloud or cloud-hosted applications, I'll refer to them as, is that customers they can sometimes forget that you are outsourcing a lot more responsibility when it comes to cloud. So what I mean by that is, from I suppose comparatively to on-premise Escrow agreement, you usually generally host that yourself on your own infrastructure. The software's there running. If the software provider fails, it doesn't necessarily mean that software is going to fall over the next day. Yes, it will naturally deteriorate over time, and you do need to support and maintain that, which is where obviously the source code element and Escrow verification comes into play. But from a cloud perspective, you're outsourcing pretty much everything to do with that application, and obviously there's a whole host of benefits as to why people do that. But ultimately, you're outsourcing the application to an environment that you probably have never seen and may never will see or have any understanding of. You're just trusting your software vendor to run that for you. And also your data sits on there as well. So you've got not only the application, you've got all of the knowledge around the infrastructure, and you've got the data that sits there as well. And data very rarely comes into consideration for on-premise agreements because, again, it's sitting within your own service. So if you need to access your database, just speak to your IT team and get access to it via that format. You can't just ring up, AWS and Google's of the world and say, I need access to that database on an environment that I've never had access to and I don't contract with you directly. So that's really where I suppose the contracts differ slightly. It's the type of material that we hold to enable more resilience and continuity around the actual Escrow scenario, because there's an increased level of risk in terms of what you're outsourcing to your outsourcing provider. It's the additional type of material that we hold as part of that contract. So that can be, we extended that quite extensively, and there isn't I suppose a finite list, because we do utilize quite heavily cloud technologies to enable us to not only store and utilize that material, but ultimately it just gives us more flexibility in terms of what we can offer as part of Escrow. And what I mean by that is we can store virtual machines, we can store containers, we can store entire cloud subscriptions if customers want us to, because we've got a great relationship, or a great partnership, shall I say, with Amazon Web Services and Microsoft Azure. We essentially utilize their platforms to store the cloudy material, for want of a better phrase again. And what that means is that from a customer's point of view, if they've got recovery time objectives, for example, for this application that may be for 3, 4, 5 hours, 2 days, whatever, depending on what the criticality of the application is, we can almost replicate to some extent, or replicate at points in time, material from the production cloud environment over to a cloud environment that's hosted and managed by NCC Group as part of that Escrow engagement. So appreciate I'm throwing quite a lot of information here, and I'll probably pass over to Nicola to give everyone a break in terms of the technical detail. But ultimately, that's the key difference. There's a key difference in risk. Contractually, it's similar, I would say, although Nicola will I'm sure, pick up on that point in a bit more detail. And technically, it is very different as well, because there are so many, when it comes to cloud technologies, there are lots of 3rd, 4th, 5th, and 6th parties that get engaged in those types of arrangements, so to speak. Not very rare that we see now in cloud-hosted applications that the entirety of the application is authored by one sole supplier. They utilize, APIs, etc., from data providers, or they utilize cloud-hosted technologies as well. So something that AWS are offering as part of their marketplace, for example, they can tie into that as part of the application. So that's really where environments are getting more and more complex. So the Escrow solution is naturally getting more complex from a technical point of view. But the reason we're doing that is to make sure that we're offering, or can offer, a whole host of type of escrow material that will enable fast and reliable business continuity and service restoration after a point of failure.
Okay.
I think it's important to note, actually, as Jamie highlighted there, escrow arrangements at the beginning of the call, we talked about a 3-party arrangement, but we do accommodate kind of 4, 5, obviously multiple parties, because we have multi-licensee agreements. And one thing we found with EAS is that we started out with 3-party agreements, and we've very quickly seen demand for 4-party agreements. So you might have a distributor, an owner, as well as the licensee and us. So we will try and accommodate and reflect exactly the scenario that we're presented with. So that's why the solutions architects really come into their own to make sure that the right situation, the right solution is provided, and that we're getting material from all the correct parties. In terms of the EAS agreements, the main difference is the definition of the material. So obviously in a source code agreement, we're asking source code to be deposited. In EAS, access credentials are very important, making sure you've got a replication of the environment. Do you need your data to be involved there? Is there anything else you need? So it's really making sure that you've got the full suite of documentation, so that it really can be a bit of a lift and drop, which is why we talk about replicate. For release, obviously the impact if your SaaS solution goes down is going to be more immediate, because it's not, as Jamie said, hosted on your own infrastructure. So because it's more immediate, our normal release events have a 14-day period, so that the owner can object. We've made that 3 days for release, just so that it's much quicker. And if it's a scenario such as insolvency or bankruptcy, which can be evidenced through court documentation or administrator appointments, then we'll release immediately, because obviously that event is factual and wouldn't be disputed by the owner. So we're really trying to make sure that our solution is flexible by hosting and holding the material in the cloud, as Jamie said, where we're working with AWS and Microsoft Azure, then we can release it very quickly as well.
Okay, and in terms of costs, is that normally borne by the customer, or is that something the vendor pays for?
So from I suppose, looking at the history of our escrow arrangements, I suppose if you take them all in their entirety, cloud, on-premise, etc., all bundle those into one, I would say probably 95% of those are paid for by the beneficiary or the customer, as we call them, the organization who is benefiting from the escrow agreement. But in some cases, we have our partnership program or our technology partners where we engage with directly. We come up with, I suppose, we engage with them on favorable terms for that technology partner. And by technology partner, I'll sort of dial that down to the author of software, the independent software vendors that we work with. And ultimately, in some cases, we have fantastic engagements with ISVs and with these technology partners, whereby we go and speak to their customers collaboratively and together to say, okay, we understand that this is going to be, for example, in financial services, at software escrow will land on your doorstep if you're a software vendor at some point in time, whether it's pre-procurement, post-procurement, whatever it's going to be. If an application becomes more critical with an organization or within a financial services, escrow will appear at some point in time. And that's just what history shows us by working with these organizations. So when we work with some software vendors proactively, we have the agreement, we have the terms, and we can go to their customers together and say, look, we are being proactive. We know that you're going to ask for this at some point. This is what we think is going to look best for you. NCC agree with that approach as well. So let's implement that when the time is right. And we've had some great successes doing that as well. But again, I suppose to answer your question, more often than not, 95% of the time, it will be beneficiaries who pay for that service.
Okay. Yeah, and we've seen instances where you've got the vendor who's paying for the escrow agreement, and part of the agreement with NCC Group or the escrow agent is that the relevant material would only be released, on the condition that the fees have been paid. And so we see some unscrupulous vendors not paying the fees as a means to get out of having to release the material. But from what I understand, in those sorts of scenarios, NCC Group would allow the customer to instead pay for NCC's fees in order to obtain the material. And then obviously, the customers then got a claim to go after the vendor for, not having abided by the terms of the escrow agreement, requiring the vendor to have paid for the fees.
That's exactly right. Well, yeah, obviously non-payment, we'll always make sure we get payment for those annual fees. Verification fees are less of an issue because they'll be paid at the time by the parties, and an owner's usually involved, and a licensee will often pay for those fees. So really we're just talking about an annual fee, which will only ever be 1 year's annual fee. So we then, if it's not paid, we go to the licensee and say, would you like to pay so that the escrow can continue on? And they will often do that and then apply for release, because non-payment is obviously an indicator of insolvency or other issues usually with the owner. But we would never just terminate. We'd always make sure we spoke to the parties, and we'd make sure we do it promptly so that the fees are never kind of building up over 5 years or anything like that. So a licensee shouldn't be just presented a huge bill or anything.
Okay. And in terms of a release event occurring, so in the context of a as a service model or cloud services, how does the cost allocation for that work? Is it simply that the customer pays NCC and then NCC pays the relevant fees to AWS or Microsoft Azure, if that's the case?
Yeah, so from a just make sure I'm not unmuted. Yes. So from a cloud perspective, I think maybe if you'll allow me, Haroon, I think it may be worth me sort of giving almost the end-to-end process. I'll give you an example of one that we've worked on quite recently. Unfortunately, it'll have to be an anonymous example, but I do have plenty of other non-anonymized examples that we can run through in a little while. But ultimately, so we engage with a financial services organisation, or we have been engaged with them for a number of years. They're one of our long-standing customers, and they came to us with a requirement for a particular software application that was hosted on Microsoft Azure. And it was quite a unique scenario, actually, whereby we were aware that they were planning on terminating the agreement, or there was some sort of financial difficulty with the fintech provider that they had been made aware of. So ultimately, they were ramping up, I suppose, what escrow they have in place, because they were anticipating that perhaps a release event was going to come within the next sort of 6 to 12 months. Granted, it may or may not happen, but ultimately that's the indication that they had got. So we went down and offered a escrow as a service agreement, which is our sort of cloud escrow offering, if we've not mentioned that previously. And ultimately, the way that we protected that is we created a brand new Microsoft Azure subscription. We worked with that software vendor to essentially replicate the material that sits in that environment. So replicating from an application perspective, replicating the data, and making sure that that is as up to date as possible. I think it's every half a day all of that material is updated. So sort of the top end in terms of escrow service, I would say, in terms of not only cost, but obviously the resilience and the assurance that gives you. We also verified that material. Our consultant worked with the technology team, the software vendor team, to make sure that we understood exactly how the Azure environment worked, what third-party tools are being used, etc. And essentially, if a release event happened, that was fully documented. Now, what would happen, I suppose, is your ultimate question, and I've gone a long way around to it, Haroon, but what would happen in that release event scenario? Ultimately, what we would do, because we have a Microsoft Azure subscription, which is completely segregated for this customer to hold all of their relevant material, we own that at the moment. We have contractual obligation against that environment. It sits under NCC Group's licensing agreement with Microsoft. And ultimately, in a release event scenario, what would happen there is we would engage with the financial services organisation, that we would then essentially transfer ownership of that subscription over to the client, over to the financial service organisation. So that means that they don't, if you compare that to on-premise, what you would usually get is, well, historically you would get a CD, etc., a USB drive with the source code, and obviously the verification material that sits on top of that. Whereas now, from a cloud point of view, because there's lots of cloud-specific technology that needs to sit in that escrow agreement, the application, source code, of course, as well, because even though it's a cloud-hosted application, it's still created by source code, which I'm sure will come as no surprise, and obviously the data as well. So from a customer point of view, what they will get is almost a production state Microsoft Azure environment that they can then continue to run internally. And fortunately, they have the expertise internally to understand and run that environment going forward, in addition to obviously the documentation that we've been providing as part of the verification services. So if you think from a longer term business continuity or general continuity strategy for that application, the bank will get a production state environment with all the relevant material and all the relevant data to enable that restoration excuse me, of service, not only after a point of failure but going into the future. And then at the moment they're still I suppose, just for complete transparency, they're still working out exactly what that longer term strategy is going to look like. More often than not, customers will migrate to a new provider. It's very difficult to, I suppose, manage and maintain a service that you haven't authored, obviously a production state service that you haven't authored for a long period of time. Some organisations do it depending on the complexity of the application, but more often than not it will be migrated perhaps over a 6 to 12 month period to a new provider. But hopefully that sort of gives you a flavour of what that sort of end-to-end process would look like, and I suppose the additional value that Escrow as a service gives you. You know, if you compare that to on-premise, where we still have some on-premise arrangements that are implemented for cloud applications, just because organisations don't understand the risk difference, they don't understand, you know, why it needs to be different for cloud as opposed to on-premise. But ultimately, if you think in comparison to what they're getting now in terms of an Azure subscription to what other organisations may be getting, is just the source code to deploy to a cloud environment that they don't know how to utilise. I guess that's really where I suppose the stark difference is in terms of the service, which hopefully has been fairly clear.
Okay, and we're seeing a change in the market in terms of, as you just touched on previously, the vendors coming, you know, from the outset and saying to the customers, you know, we know you want to have this escrow at some point. So rather than, you know, negotiating separate escrow agreements with every single customer, we're going to have our own standard escrow terms. And as they pick up more and more customers, then those customers would be required to sign on to those standard terms. Are you seeing instances where those sort of vendors, particularly fintech vendors, are happy to negotiate addendums to the standard terms?
So we often offer kind of the confirmation agreement, which is that registration agreement you're talking about, up to the multi, can have certain variances for a licensee. For example, they might have another release event, but the material that we hold on a multiple arrangement is one set of code for all of the licensees. So if you were saying, well, actually, I want a replication of my entire environment, then we'd recommend that you signed up to that source code arrangement, and then you had like a replicate EAS agreement as well, just for you, for that situation. So it really depends on kind of the leverage between the parties and your relationship with the vendor and what you're expecting them to deposit, whether that multi arrangement will be suitable for you.
Okay. I'm conscious of time. Sorry, Nick, go on.
No, I was just going to ask, like, so we do a lot of work in advising people on the various sort of, you know, cloud regulatory considerations in the region, and particularly for me in Saudi. So there are restrictions there that would, you know, potentially impact on the use of cloud services located outside the kingdom, possibly, you know, for government sector clients, and in some instances for private sector clients. And I just wonder how, you know, how that might impact on the use of NCC as an escrow provider. Can you talk a little bit about that?
If I'm understanding your question correctly, Nick, you're referring to, I suppose, kingdom organisations utilising cloud technologies outside of the kingdom. Is that a fair assessment of your question?
Yeah, that's right. So there are restrictions in Saudi, but I guess just thinking it through, you know, the escrow service that you offer doesn't have to be a cloud service. It could actually be, you know, a traditional escrow service, and therefore you could essentially get around any restrictions on using cloud services outside the kingdom just by providing the traditional escrow services. Does that make sense?
Yeah, I think so. Yeah, so I think quite a big technological change that we have implemented recently is to, I suppose, migrate or start to migrate what has historically been a lot of our on-premise escrow agreements, where the material is actually physically stored on physical media within a physical vault that's sat in different geographical jurisdictions. And a change that we have made recently, and is an opt-out sort of change, is whereby we will start to store the majority of our material via our virtual vaults function. So we work with Microsoft Azure. They're our chosen provider in this sense, in terms of where we're going to store that material. And I think the direction I'm going as part of this description is that working with the likes of Microsoft Azure gives us more flexibility in terms of where material can be held. So, for example, at the moment we have 4 physical geographical locations in EU and US in terms of where we store the material. Whereas now, working with Microsoft Azure, it opens up lots of different areas in terms of, or I suppose as Microsoft call them, regions where we can store that material. So if customers want to start storing that in Singapore, in the Kingdom, etc., and unfortunately, I'm sorry, I won't or can't list off exactly those regions off the top of my head, but ultimately it gives us much more flexibility, especially as those new regions start to come into play. We've got lots of different, I suppose, legal contracts in relation to jurisdictions. I think we've got over 15 different agreements that reference different local laws, which will again contribute towards depending where that material can be held. So we give customers lots of flexibility, is what I'm trying to say. Ultimately, if you want to store material somewhere, that's absolutely fine, and ultimately if you want it to be in a particular law, that can be absolutely fine as well. I think where I suppose sometimes the discrepancy comes into play is where a software vendor may want to store something versus where a customer may want to store something, because ultimately the intellectual property and what's stored underneath the escrow agreement for the lifetime of the agreement pre-release event, I suppose, is still the intellectual property of the software owner. So they have to be comfortable where the material is being held as well, which can, I suppose, you can have plenty of conversations with customers and vendors around that particular point. But ultimately, flexibility is key to our escrow agreements, I think, is my summary point there.
Yeah, and I just add to that, obviously, you know, export laws, and we're very mindful of, and, you know, GDPR, personal data, where that should be stored. So we'll always work with the parties to make sure that where we're storing and what we're storing is you know, on point and in the right place.
Yeah.
Okay, I'm just conscious of time, so I think we had a couple of questions that we'll address, and then we'll call it a day. So please give an idea about the costs per annum for holding or verifying source code for ERP software. Would you have a ballpark figure for that, Jamie?
Yes, absolutely. So ERP software specifically, difficult to, I suppose, put a specific cost on that, but for a cloud-hosted software, I suppose, of that size, if you, from a contractual point of view, if you just wanted the software escrow contract, I'd say probably in the region between $4,000 to $5,000 US. And that's just for the contract, so no verification, no consultancy, etc. If you wanted to add a layer of consultancy on top of that, it would be, you'd be looking at an additional between sort of 12 and 15, or 12 to $18,000, I would say, depending on what level of service that you want. I think, as I hopefully have illustrated as we've been through this service, is that escrow is a tiered approach. You know, we do try and join it up to how customers want to assess their applications and how they procure their services, etc. So if you want to sort of the top whack, the service that I described previously in terms of that sort of real-time replication within Azure, that would be sort of the top end. That solution would be in the region contracts and services of in excess of $20,000. But ultimately, we have some customers who just have the contract. You know, that's a low-level application, just the contract between $4,000 or $5,000 I would say. So hopefully that gives you a bit of a flavour in terms of the overall scale of services that you can have.
Okay. And is it possible to store the escrow material in country? We've seen some government entities in particular that want escrow material, for example, to be located in the UAE or the KSA. I mean, NCC groups based in the UK. So how do you get around that?
So our vault locations at the moment, physical vault locations, are in the UK, Central Europe, and North America. However, from a, I suppose, towards from a cloud perspective, and I suppose maybe what I didn't say clearly before is that any material, whether it's on-premise source code or whether it's an entire cloud subscription, we can utilize our Azure partnership and our vault system within Azure to be able to store that material. So ultimately, we give customers complete flexibility. If you look at which Azure region suits you best and suits your requirements best, we're comfortable to store it in that region. We have security set up within every single region within Microsoft, and we have the infrastructure in place for our virtual vault system that sits within Azure. So I believe from memory, UAE does have, or Microsoft does have, a data center for the UAE. for KSA, I'm not 100% sure. But ultimately, we are the flexibility of Microsoft at the moment, and we are expanding that to other cloud providers. So as the next 6 to 12 months, I won't name exactly which partners, but ultimately we are going to expand that to some of the other technology giants within the hosting technology giants in the marketplace, that we can offer as many countries and regions where that material can be stored as possible.
Okay, wonderful. Any closing remarks? We've got a couple of minutes left. If you've got any burning questions or comments? No? Okay.
Is that directed to myself, right?
Oh, to everyone, to yourself, Nick, Nicola, and Nick.
I think I'd encourage people, like, our templates are available if you request them, and once you're engaging in your license agreement, then start thinking about escrow and what you want it to look like. We can set up templates for clients, so they have their own template which is tailored with all of their kind of everything they want. So once you've got the lawyers involved, once you've got Tamimi negotiating that agreement for you, then you can then kind of replicate it and use it again and again. So we'll just work with clients in that way. So I just encourage people to yeah, get in touch if you need any help.
I think that point about doing it at the same time as you're negotiating the main agreement, you know, that makes a lot of sense. It's not something I've thought too much about before, but you know, you've got a lot more leverage if everything's still being discussed than if you were just to basically include in your sort of main agreement some sort of obligation to sit and talk with the counterparty about an escrow agreement at some stage in the future. It's just not as solid.
Yeah, we often find that our kind of quick turnaround or agreements are where they've brought it in at the 12th hour, and it's part of a massive kind of buyout or something else, and so then the agreement gets turned around really quickly, and we'll make sure that we work with the timescales that you need it.
I think as well, I suppose my closing remark is around, I suppose, the escrow governance, I suppose, discussion that we had previously. You know, again, to Nicola's point, do reach out. You know, we're happy to support you. It's in everybody's interest in terms of getting escrow governance to a good point where it's easy for, you know, everybody to utilise it and for it to be consistent across an organisation. So we have been in the market for a long time. We understand, you know, what the patterns are, not only within the overall market, but within specific industries as well. So obviously it's for customers to decide exactly what they want, but we can use a lot of best practices, a lot of documentation, a lot of frameworks, etc., where we can help you standardize. It doesn't have to be a huge outtaking or undertaking or piece of work in order to do that. So do reach out if it's something of interest or something that your organization is struggling with at the moment in terms of getting some consistency and governance around escrow. I think that's my final remark.
Okay, wonderful. Well, on that note, we'll call it a day. Thank you, Jamie, Nicola, and Nick, for joining us and our attendees. We'll send through the email with the further details and a copy of the recording as well. Thanks again, and enjoy the rest of the day. See you.
Yeah. Thanks, everyone.
Thank you. Take care.
Yeah.
Bye.